I am now turning it over to Danielle Brennan from our Palm Beach Gardens location, who will tell a little bit about herself and then get right into the material. Danielle?
Yes, good morning. Thank you so much, Jeff. And thank you everyone for attending today. We do have a long day of education, and I'm glad I get to be the one to kick everything off for you. So let me go ahead and start with the presentation. I will give you a little bit of spiel about myself and about the firm. As Jeff said, I am one of the board certified specialists here in K. Bender Rembam. Hold on one second while I try to figure out what just happened
Technology
here.
is wonderful when it works the way we
Yeah,
anticipate. And I've got mine ready if you're having a glitch. Just let me know.
no, the glitch is I am the glitch.
All right, back to you.
Okay. All right, so I think here we go. I am one of the board certified specialists here in the Palm Beach Gardens office. As you can see from the slide, we do have a number of offices because I am one of 24 attorneys at K. Bender Rembam. This is what we do day in, day out. We specialize in providing expert legal services for community associations throughout the state of Florida. There is probably not a legal issue that a community association has that we have not handled in the past. I'm here in the Palm Beach Gardens office. We have our main office in Broward County, Pompano Beach, with offices also in Winter Springs, Tampa, and Miami-Dade by appointment. Like I said, there are a number of board certified specialists. We have 9 in condominium and planned development law, 1 in uh, construction law. And this is what we do day in, day out. I'm trying not to say so much, and I've realized I've said it 10 million
Let's
times
get
right
the
now.
over under. Maybe we can give away a prize for how many. Just kidding. Back to you.
I know it's so terrible. So let's go ahead and start with the presentation. Like Jeff said, this is just for educational purposes only. It's not to be construed as legal advice. If you need legal advice, contact your association's attorney. If you don't have one, we are here to provide you with those expert legal services. Or if you want to change your legal advisor or want to get a second opinion, please feel free to contact us. If you enjoy taking these free courses, go to kbrlegal.com. We have an events web page that you can sign up for all of these free legal courses. We have a bunch of them available. Here's a little bit about me. I have been here with K. Bender Rumbom for about 13 years now. I'm a partner in the Palm Beach Gardens office. Got my start here way back in April of 2013, so been here quite some time. Now, turning into covenant enforcement. The way that this course is laid out, we try to go take you from the first steps to what could ultimately happen through the enforcement process into pre-suit, being mediation or arbitration, into litigation, and then possible defenses. So once you see possible defenses, that's going to be your cue that we're about to be wrapping up the presentation. So covenant enforcement, the association through its board of directors is charged with uniformly enforcing the governing documents. Now, our governing documents, our declaration, be it a declaration of covenants, restrictions, or a declaration of condominium. Our articles of incorporation, which is like our formative document that says we are a Florida not-for-profit corporation with officers, directors, and these are our powers. And then we have our bylaws, which are our how-to provisions. How do we hold a meeting? How do we adopt a budget? And then finally, our rules and regulations, which are typically adopted by the board, have to be consistent with the declaration, and they handle more of the day-to-day operations, like bringing in your trash can after it's been collected, dealing with holiday lights, picking up your animal's poop from the common areas, what have you. So those are our different governing documents that we have for our associations. When we're talking enforcement, though, we're really discussing the use rights use restrictions set forth in the declaration, and also the rules and regulations. Not so much talking about the articles or the bylaws, because those are more so our corporate documents. The failure of the association to uniformly enforce the covenants in a timely manner can result in a waiver or forfeiture of enforcement rights, and we'll discuss that when it comes to the defenses toward the end of the presentation. Now, when we're talking about these covenants, what kind of covenants are there that can be enforced by the association? Well, like what I said before, we're looking at our declaration, we're really looking in the rules and regulations. For an HOA, we might be enforcing architectural standards for alterations to their parcels, their lots. Maybe we're housing for older persons and we have a 55 and older requirement. Maybe we have a no pet rule, or we have a pet weight or pet number limitation that we're enforcing. Maybe there's a sale and leasing requirement. Maybe guest occupancy is limited to 30 days in a calendar year and somebody has violated that. Parking and vehicle restrictions, the hot topic a couple of years ago, maybe it was last year, in HOAs was about pickup trucks. Perhaps you have a truck prohibition in your governing documents. And then something that we all have in our documents is the nuisance conduct, where it prohibits people from impairing others' right to peaceful enjoyment of the property. So we know what the covenants are. Someone has violated those covenants. What do we do next? So typically the first step in an enforcement action is to send the owner or whomever is violating that covenant a notice of violation. Whether you call it the first notice of violation or a courtesy notice, it does not matter. Typically this notice includes a statement of the violation. What is it that the person did? What provision of the governing documents was violated? And if the violation is subject to a cure, how can that violation be cured? Florida statute was changed last year pretty heavily with HOAs with regard to how the covenants are enforced from a fining, use rights suspension perspective. And we'll get into the nitty gritty of that very shortly. So, excuse me. There are certain violations which are subject to a cure, and there are other violations which are not curable, meaning once the violation happens, there's nothing you can do to rewind the clock to take it back. So, for example, maybe it's a parking violation. Once you've parked somewhere in violation of the governing documents, it's not like you can undo that violation. The next occurrence of that would be another violation, right? Whereas if it's something like maybe they haven't cleaned their roof in quite some time, they need to do that. Well, then they can go out there, clean the roof, and bring themselves into compliance. So you send out that first notice, they don't comply. Maybe you provide them with the courtesy of a second notice, a second opportunity to bring themselves into compliance, and they don't. Well, if they don't voluntarily comply with the association's demand, then the association can think about next enforcement steps. And what do these enforcement steps include? Well, we have fining, suspension of use rights, suspension of voting rights, but the suspension of voting rights is limited to monetary delinquencies, and we'll talk about that some more. Self-help if it's authorized by the governing documents, and then once we're positioning ourselves for litigation, and then we'll talk about mandatory pre-suit mediation or non-binding arbitration, and if none of that works, then we're into litigation. So first, fining. Fining is a statutory remedy, and these are these particular statutes where you will find the authority to fine for our condominium associations in Chapter 718 and our homeowners associations in Chapter 720. The association can levy reasonable fines for violations of their governing documents. Again, we're really looking at the declaration and the rules and regulations for these particular violations. And the authority to fine doesn't have to be provided in the association's governing documents. It's a statutory remedial measure that can apply to your association. For our condominium associations, the Florida statutes limits the amount of the fine per violation and in the aggregate. A fine cannot exceed $100 per violation and it cannot exceed $1,000 in the aggregate. Also, a fine cannot become a lien against a unit. So if you're in a condominium association, you've accrued all of these fines against a unit, you can't then lien it like you would be able to an assessment. You would be going into a court seeking a money judgment in order to collect on that fine. For our homeowners associations, it's very different, similar but very different. A fine cannot exceed $100 per violation unless otherwise provided in your governing documents. So your governing documents can allow fines to exceed that $100 limitation. Similarly, a fine cannot exceed $1,000 in the aggregate unless otherwise provided in the governing documents. So you're really going to want to look at your governing documents if you're in an HOA to determine whether or not you're subject to these statutory limitations or if you can exceed them. Also, a fine of less than $1,000 cannot become a lien against a lot. Really should say lot there, not unit, right? So a fine of less than $1,000 can't become a lien against a unit, but once it hits that $1,000 mark, you should be looking at your governing documents to make sure that you have the authority there to actually assess and lien for those fine amounts. So now that we know we have the authority to fine, how do we begin that fining process? So the fining process for both our condominium associations and our homeowners associations first require the board's levy of the fine and then confirmation of the fine by an impartial committee at a hearing. The fine can be levied by the board for each day of a continuing violation with a single notice and hearing by the committee. After the fine is levied by the board, then the association has to send written notice of that committee hearing to the member or to whomever is being violated there at least 14 days before the hearing. So that hearing notice for our HOAs has to include a description of the alleged violation, the specific action required to cure the violation if it's a curable violation, the hearing date, location, and access information if the hearing is going to be held by telephone or other electronic means. Certainly, when the HOA Act was changed last year in the 2024 legislative session, they did make a lot of procedural changes that are, in my opinion, detrimental to the association's ability to levy fines and use right suspensions, as you'll see. But we did get the benefit of using technology. So you'll see the differences between the HOA and the condo when it comes to the use of technology, email, or video conferencing for the fining and the use right suspension process. So here, the committee can hold the hearing by telephone or other electronic means for our HOAs, and the owner has the right to attend that hearing by telephone or those other electronic means. Now, that hearing has to be held within 90 days after issuance of the hearing notice. So you have to at least provide 14 days advance notice of the hearing, and that hearing has to be held within 90 days of providing that notice. The hearing committee, so this is for both condominiums and HOAs. The committee must consist of at least 3 members that are appointed by the board who are not officers, directors, or employees of the association, or the spouse, parent, child, brother, or sister of an officer, director, or employee. This is about your familial relationship, not necessarily about what home they live in, because I know this was brought up in our last class. If you are in a community, you own your home, you're on the board, your brother lives in another home, owns another home, and wants to serve on the fining committee, the hearing committee, well, he can't because he's your brother and you are a director, notwithstanding the fact that he owns and lives in another home. The role of the committee is limited to determining whether to confirm or reject the fine that's levied by the board. So let's say the board levied a $100 fine for the owner's failure to mow their lawn. And the committee says, well, yes, he did have that violation and we do think he should be fined, but we don't agree that the fine of $100 is fair. We want to lower it to $50. Well, in that case, because the committee is not approving the fine as levied by the board, that action is in fact a rejection of the fine levied by the board, and it would require for the fining process to begin anew. Because once they do that, that fine is actually rejected, then that fine cannot be imposed. So they really need to be matching whatever the board is doing. Otherwise, it can't be imposed. After the hearing for condominium associations, if the fine is approved by the committee, the condominium association must send written notice of the fine by mail or hand delivery to the owner or to whomever it is that is being fined. And the fine payment is due 5 days after notice of the approved fine is provided to that person.
Hey, Danielle, I got to cut off for a second. My Zoom interface is acting wonky. I need to log out and come back in. It will not affect the class. You can keep going. But
Okay,
when I
cool.
disappear, please don't worry. I'll be right back. I can't type
All
anything.
right.
I can't. Okay. I'll be right back. Keep going.
All right, no problem. So for our homeowners associations, a couple of years ago, it used to be the same exact thing as the condominium associations. But again, the 2024 legislature decided, you know what, we're making a bunch of changes to our homeowners associations, fining and use right suspension capabilities. So for our homeowners associations, within 7 days after that hearing, the committee must mail or email written notice to the owner and whoever else is being fined. And that notice has to include any applicable fines that the committee approved or rejected, how the owner or other parcel, occupant, licensee, invitee can cure the violation if it's a curable violation, and the date by which the fine must be paid. So how do we set that date, right? The committee has to be setting the date the fine is due at the committee meeting. I think I've gone away now, Jeff.
No, I still see you.
Oh, okay. That's strange because it changed on my screen. Apologies. So the committee, if they're going to approve the fine, they need to set the date by which the fine has to be due. And statute also requires that the fine has to be due at least 30 days after delivery of that post-hearing notice. So the committee kind of has to be a little bit clairvoyant and have a crystal ball to determine, okay, we need to provide them with at least 30 days. And they also have to provide some time for the notice to be actually delivered. So you definitely want to be sending that that post hearing notice by some kind of trackable delivery method. That way you can ensure that they actually received it, and then you'll know that they are required to pay that fine. If the violation, again, with the I apologize, if the violation has been cured before the hearing or in the manner specified in that hearing notice, which is that 14-day notice, or the notice of the committee's findings, which is that post-hearing notice, then the fine cannot be imposed. This is something that was created by that 2024 legislative session, which essentially says, well, if they cure the violation at any point in time during this fine process, they're not going to be having to pay the fine. Even after the board has levied the fine, they've had the hearing and the committee agrees with the fine and has sent notice of that post-hearing determination. They're not going to have to pay the fine. So presumably, if they've paid the fine after being sent that post-hearing notice, well, then it's not like they're going to be entitled to a refund of the fine. But certainly, if they get that post-hearing notice and they cure the violation after receipt of that notice, then they won't have to pay the fine. With regard to attorney's fees and costs cannot be awarded against the owner based on actions taken by the board before the date set for the fine to be paid. So for those associations who are used to involving their attorney in this enforcement process, Not to say that you don't want to do that, but be mindful of the fact that the attorney's fees that are being incurred may not be recoverable before the date of the fine is to be paid. So a consideration to be made. If the violation and the fine that's levied by the board is approved by the committee and the violation is not cured or the fine is not paid pursuant to that notice, the post-hearing notice, then reasonable attorney fees and costs can be awarded to the association. And again, attorney's fees and costs cannot begin to accrue until after the date notice for payment and the time for appeal has expired. So notice that there's reference to a time for appeal. This is the only reference in this particular statute regarding an appeal of a fine that's approved, that's levied by the board and approved by the committee. You're really going to have to look at your governing documents for this. There's no appeals process in the Florida statute. Perhaps your governing documents provide for an appeals process. I have seen it before. So look at your governing documents to see if there is any appeals process. If not, then obviously one is not provided for the owner, whomever is being violated here. So when we're looking at attorney's fees, again, prior to the time that the fine is due for payment, you may or may not be able to recover those attorney's fees later on. Also, the 2024 legislative session, I keep referring to these people because they did make a lot of changes. They built in some special considerations for our homeowners associations when it comes to two particular types of violation. Notwithstanding any provision to the contrary in your governing documents, the HOA cannot levy a fine for leaving garbage receptacles at the curb or the end of the driveway within 24 hours before or after the designated garbage collection day or time, or for leaving holiday decorations or lights on a structure on a lot longer than indicated in the governing documents, unless they were up for longer than 1 week after the association provides written notice of the violation to the owner. So that's not to say that the association can't have these rules in place or that the association can't then enforce those rules. It's just building in extra time for the owner to cure those violations before the association can go down the route of a fine. So I know a lot of HOA board members are like, well, why do we even have these rules then to begin with? Well, it's still worthwhile to have the rule just in case you have someone who's really violating these particular rules, because you can still enforce them. There are just some procedural measures you have to take into consideration before you go down the fine or the use right suspension route, which we will now get into. Again, use right suspension, these are the statutes for our condominium associations in 718, Chapter 718, and our homeowners associations in Chapter 720. The association can suspend the right of an owner or their tenant, guest, or invitee to use the common areas. In our HOAs, we call them common areas. In our condominiums, we call them common elements, or generally the common facilities. If a member is more than 90 days delinquent in paying a fee, fine, or other monetary obligation due to the association, notice it's more than 90 days delinquent. So it's not on the 90th day that you can suspend use rights, it's on the 91st day. You also have the authority to suspend use rights for failing to comply with any provision of the association's governing documents. So similar to the authority to fine, you do also have the authority to suspend use rights for failure to comply with the governing documents. A use right suspension does not apply to, in our condominium associations, the limited common elements that are used by that unit alone. Common elements needed to access the unit, so the hallways, what have you, utility services provided to the units, parking spaces, or elevators. So they need to be able to use the property in order to access and leave their unit. In our homeowners association, a use right suspension does not apply to common areas used to provide access or utility services to the lot, including vehicular and pedestrian ingress and egress to ingress to and egress from the lot and the right to park. So similarly, we can't be blocking their ability to get to and leave from their home. But you can do it for everything else, like your recreational facilities. They won't be able to use the pool or the fitness facilities or the tennis courts, what have you. The suspension applies to the owner and, when appropriate, their tenants, guests, or invitees, even if the delinquency resulting in the suspension arose from less than all the multiple units or parcels owned by that owner. So, for example, let's say I own a unit in ABC condominium and I became delinquent. The board levied a use right suspension for my delinquency, and I own multiple units within that condominium. Well, that use right suspension will not only apply to the unit for which I have the delinquency, but also to those units that I own within that condominium. For monetary violations, remember we have the ability to suspend use rights for both monetary violations and non-monetary violations. Again, the delinquency has to be more than 90 days past due. The suspension must be approved by the board at a properly noticed board meeting, but there's no requirement for this then to go to a hearing before an impartial committee. Once it's approved by the board, the association has to send notice to the owner and, if applicable, to their tenants, occupants, licensees, invitees in our condominium associations by mail or by hand delivery. And in our homeowners associations, again, we got that extra kick of technology by mail, hand delivery, or email. And the suspension will end when the delinquency is paid in full. Now, for our non-monetary violations, the use right suspension must be for a reasonable period of time. Typically, I see 30 days. The process for both the condominium associations and the homeowners associations require the board's levy of the use right suspension and then confirmation of the suspension by the impartial committee. This is going to be the same exact process as the fining process. So I'm going to run through this a little bit faster than I did the initial fining discussion. So after the use right suspension is levied by the board, you send that 14-day notice to the person that's being suspended. For our homeowners association hearing, the hearing notice, description of the alleged violation, specific action required to cure that violation if it's curable, hearing date, location, and access information if it's held by telephone or electronic means. Again, the hearing has to be held within 90 days after issuance of that hearing notice. And we do have the added benefit of using electronic means for holding the notice and for owners attending that hearing. Again, the hearing committee is at least 3 members who are impartial, not officers, directors, or employees of the association, or the spouse, parent, child, brother, or sister of a director, officer, or employee. They can only confirm or reject the use right suspension that's levied by the board. And if they don't approve it, well, then the use right suspension cannot be imposed. Excuse me. For our condominium associations, if the use right suspension levied by the board is approved by the committee, then the condominium association sends that written notice, that little love letter there, by mail or hand delivery to the person who's been violated. For our homeowners associations, again, we have to have that post-hearing notice within 7 days after the hearing. It can be mailed or emailed and has to include this information, whatever the suspension was approved or rejected by the committee, how they can cure the violation if it's subject to cure, and how they can fulfill the suspension. For our homeowners associations, again, if they cure the violation at any time, the suspension cannot be imposed. And what's interesting here is that they can still cure after the post-hearing notice. Now, typically with a use right suspension, once you send that notice, the use right suspension is immediately in effect. So in order to apply this particular provision to use right suspension, I think it's reasonable to say that after that hearing notice, that post-hearing notice is sent to the owner, and the suspension becomes immediately effective, let's say they cure the violation prior to the end of the period of suspension. Let's say it's the 30 days, like I mentioned before. So let's say on the 15th day, they cure the violation. Well, in my opinion, once the violation has been cured, the suspension ends. If the violation and the suspension levied by the board is approved by the committee and the violation's not cured pursuant to the notice, that post-hearing notice, then reasonable attorney's fees and costs can be awarded to the association, but they don't begin to accrue until after the time for an appeal has expired. Again, look at your governing documents to determine whether or not you have an appeals process, because the statute in and of itself does not provide for an appeals process. The same special considerations regarding the garbage receptacles and the holiday lighting and decoration also applies to the use rights suspension procedures. So we also have the authority to suspend voting rights. And I have to put a little asterisk near that because, as you'll see, the authority to suspend voting rights has come under some fire lately. But here are the statutory references if you need them for our condominium associations and our homeowners associations. An association can suspend voting rights of a member if the member is more than 90 days delinquent in paying a fee, fine, or other monetary obligation to the association. This is the only time when an association might be able to suspend voting rights. So if we have a little Venn diagram of our authority, we have monetary violations, non-monetary violations. The overlap would be the use right suspension. For our non-monetary violations, we have fining. And then for our monetary violations, we'll have use voting rights suspensions. So that's kind of like how I picture it in my head. The suspension will apply to a member and when appropriate, their guest invitees, which I know it's pursuant to statute, this language, but doesn't make much sense when it comes to voting rights. Even if the delinquency that resulted in this suspension arose from less than the multiple units or parcels owned by that member. For our condominium associations, there were a couple of procedural measures that were added, I don't know, a handful of years ago. The monetary obligation due to the condominium association must be more than $1,000. You have to provide proof of that obligation to the owner at least 30 days before the suspension takes effect. And at least 90 days before an election, a condominium association has to notify the owner that their voting rights may be suspended due to non-payment of a monetary obligation. So the suspension must be approved by the board at a properly noticed board meeting. There is no need for this particular type of suspension to go before the committee. Once it's approved, the association has to notify the owner in a condominium association by mail or hand delivery, and in a homeowners association by mail, hand delivery, or email. And the voting interest that's suspended, it's as if it never existed. So you're not going to be adding that into when you calculate a quorum, when you're conducting an election, when you're approving any action. It's as if boop, that voting interest has disappeared. The suspension will end upon full payment of all obligations currently due or overdue to the association. And as I mentioned before, the authority to suspend voting rights, typically we would rely on that statutory authority because, again, similar to finding use right suspensions, it's a remedial measure. However, this Florida's third DCA later came out to say, well, your governing documents don't refer to voting rights suspension as a manner of enforcing a delinquency. And your governing documents don't contain Kaufman language. Now, Kaufman language is that amended from time to time, which incorporates substantive changes made to statute into your governing documents. So since they didn't have the voting rights suspension language in their declaration, and they didn't have Kaufman language to incorporate that statutory language, well, the court determined you don't have the authority to suspend voting rights. So considering that this case is out there, you want to be looking at your governing documents to determine if you have the express right to suspend voting rights. And if you don't, certainly consider amending it into your declaration. Now, self-help. Self-help is very particular because it's going to be in your governing documents. That is the only place where you are going to find this authority. Usually the self-help is, hey, you guys, unit owners or owners, you're required to maintain your lot, your unit. If you don't maintain then the association has the ability to go into your unit or go onto your lot, do the work, and then assess you for the fees and costs that were incurred by the association to bring your unit or lot into compliance. And there are some examples of what that could be here. So throughout the years, associations relied on court decisions to say, okay, the association has this express authority for self-help, but they also have the ability to go into court and ask the court to order an injunction to force the person to do the work. Meaning the association had the option to choose either, okay, let's do self-help, or let's go down the route of having the court require the owner to do the work. However, there are a couple of different cases that said, no, association, if you have self-help in your governing documents, that is an adequate legal remedy in law. Therefore, you have to at least attempt to exercise that self-help authority before you can go into a court in equity and get an injunction. So here, we have our legal remedies, meaning to them dollar bills, where the association can then assess for it and then seek the money back, or in equity, forcing someone to do something, getting that injunction. And usually those equitable remedies can't be sought after until you've exhausted all of your legal remedies. So that's what's been typical, but not necessarily applicable to associations because of the statutory language that's out there. Now, those decisions came out of the second DCA and the sixth DCA, which second DCA I think is Tampa area. I think sixth DCA is like Miami-Dade. But the fourth DCA, which is here in the big Tri-County area, there's been a case that said, no, second DCA, sixth DCA, you're wrong. The statute provides that the association can seek damages or injunctive relief or both. So they don't have to exhaust that legal remedy before they can go into a court of equity. So since there is that conflict between these district courts of appeal, it's been a certified conflict. Hopefully we'll be hearing something from the Florida Supreme Court, who knows when, to resolve the conflict between these district courts of appeal. So let's say the association has gone through all of those measures in order to obtain compliance. And the owner is like, fines, I don't care. Use right suspension, I don't use the community pool anyway. And let's say it's not a monetary violation, right? So there's no voting rights suspension there. What can the association do now? Next would be pre-suit dispute resolution. Now, there are two different routes you could possibly take for a condominium association and homeowners associations. So first we'll dive into condominium associations, and then we'll dive into the homeowners associations. So for our condominium associations, we can do arbitration or pre-suit mediation. Before you go into court, you have to either petition the division of Florida Condominiums, Timeshares, and Mobile Homes, which we refer to the division as short, for non-binding arbitration, or you can initiate pre-suit mediation in accordance with the procedures set forth in the Homeowners Association Act, which we will, of course, discuss in the Homeowners Association section. However, election and recall disputes, those still have to go to arbitration with the division. And this is similar for homeowners associations, as we'll see. Or you can file the dispute in court of competent jurisdiction, depending upon where you are. Every arbitration petition received by the division challenging the legality of the election has to be handled on an expedited basis. Because recall, with our elections, we have them once every year, essentially, depending upon what your term is for your directors. So if it's not handled on an expedited basis, we could be running up a dispute that becomes moot because whatever it was that was in dispute is no longer applicable. So we want to be sure that those particular issues are handled quickly. Mandatory pre-suit dispute resolution procedures do not apply to non-residential condominiums unless your governing documents say that they do. So if you're in a commercial condominium, well, you don't have to go through these pre-suit dispute resolution procedures unless your governing documents tell you you have to. Except for disputes involving condominium termination, the only disputes that are eligible for arbitration are those between unit owners and the condominium association or its board. And this can mean any disagreement between two or more parties that involves the board's authority to require an owner to take action or not take action involving the unit or the appurtenances. And appurtenances here, we're talking about limited common elements like maybe the balcony or your parking space, or the authority of the board to alter or add to the common areas or common elements. It also could involve the failure of the condominium association to properly conduct elections, give adequate notice of meetings, properly conduct meetings, or allow inspection of books and records. And also, they will hear plan of termination issues in accordance with that termination statute. Now, certain disputes are ineligible for arbitration. Any dispute involving owner to owner or owners and tenants, those are not eligible for arbitration unless the association is going to be a party. Typically, disputes don't include disagreements that involve primarily title to any unit or to common elements, interpretation or enforcement of a warranty, anything having to do with tenants, breaches of fiduciary duty, levy of a fee or assessment, claims for damages based upon an alleged failure for the association to maintain common elements. So tenancy, money, fiduciary duties, those things will need to go directly to court and not go through arbitration. No petition for arbitration will be accepted by the division if it involves issues which are moot, abstract, hypothetical, or don't involve some kind of active controversy. You can't ask them what if. Well, what if the association does that? What if the association does this? Then what? They're not going to hear issues that are hypotheticals or completely not applicable to the existing facts. They won't hear a petition that alleges the association to failure to enforce or properly enforce the condominium documents, unless perhaps that's something that would otherwise be considered a dispute. And they won't accept a petition which alleges the association's failure to properly repair, or replace, or maintain the common elements, again, unless it affects the use of the common elements, which may be a dispute. Where a controversy involves disputes that are eligible and ineligible for arbitration, then the arbitrator has to determine whether these disputes can be severed so that the eligible disputes can be arbitrated. Otherwise, everything has to be pushed out and then you'll have to go to court for them. Petitions for arbitrations, there are forms that are provided by the division. You can go onto their website. They do have a forms link. Before you can file a petition for arbitration, you do have to provide advance notice of the intention to file a petition or other legal action in absence of a resolution of the dispute. So you will always receive some kind of notice or give some kind of notice to the other party that says, hey, this is our demand. If you don't comply with this demand, we're going to seek arbitration against you. So be sure that you have that, because if you don't have that, the arbitrator will kick your petition out of arbitration. You do have to provide that advance notice, so be sure you do. The petition also has to be accompanied by a filing fee. Again, I should have checked that filing fee because I know they didn't raise fees recently, but it was $50. It may still be $50, but a copy of the petition must be provided for each named respondent. And filing an arbitration petition tolls the applicable statute of limitations. So statute of limitations is the time within which you have to bring a claim to court. Because you have to go through this pre-suit process of arbitration or pre-suit mediation, they do toll that statute of limitations for you. Once the petition is received by the division has to confirm whether or not there's a dispute. Remember, we're not talking hypotheticals or things that are moot. Whether or not you paid that filing fee, and whether or not you complied with that advanced written demand requirement. Once all that information has been confirmed, then the division will assign it or enter into contract with an arbitrator and serve a copy of the petition on all respondents. Then the arbitrator must conduct a hearing within 30 days, and unless the petition is withdrawn or there's a continuance, the petitioner can withdraw the petition at any time in writing to the arbitrator without prejudice to refiling, meaning without prejudice means you can then go back and refile your petition for that same exact issue. Or you can be granted a continuance, has to be made in writing. The request for a continuance has to be made in writing, and except in cases of emergency, must be made at least 10 days before the date of the final hearing. Once that petition is served, the respondent has to file an answer within 20 days. Before filing the answer, the respondent can file a motion opposing the petition for those things that we talked about, like jurisdiction, or this isn't an actual cause, or failure to state a cause of action. Those things are preliminary to actually getting into the facts of the case, so they can make that motion to have the arbitration kicked out for those reasons. The division has a form for the answer, and in that answer, you need to state whether or not the facts that are alleged are accepted or denied, and then also include all of your defenses, whatever your defenses might be. And you want to be sure you're including all of those defenses, because if you fail to, then you're going to be waiving them. So, except for a lack of jurisdiction, that's the only exception there. So, you either make the defense or you lose the defense in your answer. The answer cannot include a request for relief, meaning a counterclaim. You have to then file another petition. So, for example, in litigation, if someone brings a claim against the association can file a counterclaim and have everything heard by the same court. Well, not the case in an arbitration. In an arbitration, the association would have to file a separate petition for that. Even if you are into arbitration, the arbitrator can say, you know what, you guys need to go to mediation. So you can be kicked out of arbitration by the arbitrator, and any party can request that the the issue be held heard by a mediator before or after the respondent files their answer. So even though you're going the arbitration route, you still could be kicked out into mediation. And there are different, categories or things that need to be conducted in order for referral to a mediation. But just know that mediation is a vessel by which they call it shuttle diplomacy, right? Because you're in a room, a virtual room these days. You sit down with the mediator and all parties. There are some opening statements. Then you break out into your other rooms, and the mediator goes from room to room trying to get the parties to come into a settlement agreement over the dispute. Everything that happens at that mediation is privileged and confidential. So once you're in the mediation, let's say that you don't get to a settlement in that mediation and you go to litigation, anything that was discussed during the mediation is not subject to disclosure in that litigation. The parties that pay for their own attorney's fees, and they share the fee for the mediator. There are some sanctions involved if you refuse to enter into arbitrator required mediation here. If the mediator declares there's an impasse, meaning somebody didn't show up, maybe they didn't pay their fee, the arbitration proceeding then terminates unless all parties agree in writing to continue that arbitration proceeding. Again, these are confidential proceedings in the mediation. So if there's an unsuccessful mediation and it goes back into arbitration, you're not going to be discussing or considering anything that was discussed at that unsuccessful mediation, except in a proceeding to impose sanctions for the failure to appear at the mediation conference. Again, there are some sanctions there that the arbitrator can impose. If the parties don't agree to continue the arbitration after that mediation, unsuccessful mediation, the arbitrator will enter an order of dismissal, and either party can then go to court with that. At any time after filing the petition and the answer, if there is that answer, the arbitrator will enter a summary final order denying relief, so denying the requested relief by the petitioner, if there's no disputed issues of material fact and the arbitrator finds that there's no preliminary basis for relief. At any time after filing the answer, the arbitrator can enter a summary final order awarding the relief requested by the petitioner if there's no disputes, no disputed issues of material fact, and the arbitrator finds that there are no meritorious defenses and that the petition is otherwise appropriate for relief. So you may not actually have a hearing if there's a summary final order can be applied for by the arbitrator. Our arbitration hearings, I call them litigation light because they're very much like litigation. You go to the hearing, the petitioner says their case, they have the ability to bring witnesses and evidence. There's the ability to cross-examine witnesses on both sides. So it really is like litigation light. The arbitration decision has to then be rendered within 30 days after the hearing and presented to the parties in writing. In the final order, the arbitrator can grant monetary damages, declaratory relief, or any other remedy or relief which is deemed just and equitable. So as I mentioned before, this is a non-binding arbitration proceeding. Arbitration does become binding on the parties if all parties in the arbitration agree to be bound in writing to the writing filed in arbitration. An arbitration decision is also binding if a party does not file a complaint for a trial de novo, meaning a new trial in court in which the condominium is located, within 30 days. So once that final order comes out, there's 30 days to quote unquote appeal the decision to a court, but it's really not an appeal. It'll be a new trial. Once it's binding, any party to the arbitration proceeding can enforce that order by filing a petition in court. And if the petition is granted, the petitioner is entitled to recover reasonable attorney's fees and costs incurred in those proceedings. Now, there are a number of ways that attorney's fees can be shifted. Just know that attorney's fees, generally in a mediation, you're going to be responsible for your own attorney's fees unless the parties agree otherwise. And if you're a bad actor in these pre-suit scenarios, and then you go into litigation, well, you may be paying the other party's attorney's fees, even if you're prevailing in that litigation because you were a bad actor during the pre-suit process. So for our homeowners associations, disputes that are subject to pre-suit mediation is the more prevalent vessel for pre-suit dispute resolution, although there is the ability to go through arbitration. Mediation usually is what I consider, or most attorneys would consider, to be the better avenue for dispute resolution. Disputes that are subject to pre-suit mediation requirements are those involving use of or changes to their parcel or common areas, amendments to the association's governing documents, association meetings, membership meetings, not including election meetings because division has jurisdiction over election and recall disputes, access to the association's official records, and covenant enforcement. So those are all disputes that will go through pre-suit mediation before you can go to litigation. Now, those disputes which can go directly to court include anything having to do with money, anything having to do with tenancies, and breaches of fiduciary duty. So very similar to the condominium side, right? These issues you will be bringing directly to court, not into pre-suit mediation. And again, recall and election disputes go to the division. The pre-suit mediation procedure is set forth in the statute. The aggrieved party has to first serve written demand on the responding party to participate in pre-suit mediation. There's a form that's set forth in the statute. You serve that form by certified mail, return receipt requested, and a copy gets served by regular mail. The demand to participate in pre-suit mediation has to include a list of 5 certified mediators, and then the responding party has to respond within 20 days by certified mail, return receipt requested, and with a copy by regular mail, in which they choose at least one of the mediators that's listed in that pre-suit mediation demand. Once that's been done, the mediation has to be scheduled to be held within 90 days of the date of the demand, unless agreed to otherwise by the parties. The parties share the cost of the pre-suit mediation equally, including the mediator's fees, unless, again, they agree in the settlement agreement otherwise. The mediator may require advance payment of their fees, and I find that if there's a pro se party, they usually will require that advance payment of their fees. Pre-suit mediation proceedings are privileged and confidential. So again, if you have things that are discussed in mediation fails and you go into litigation, you won't be bringing in those conversations into the courtroom. Persons who are not parties to the dispute cannot attend the pre-suit mediation conference without the consent of all parties except for counsel and a corporate representative designated by the association. If there is a quorum of the board attending a mediation, which usually we do want to have a quorum of the board, we want somebody who is able to make decisions so that we can get to a settlement. The mediation is not considered a board meeting for the purposes of notice and participation by owners. Remember, these are confidential proceedings. So even though the board quorum is going to be there and making decisions, it's not something that has to be noticed, and it's not something that has to be open to the owners to attend. Now, let's say we've sent the demand, party fails to respond, they don't agree on a mediator, they don't make their payments. What happens then? Well, that is declared an impasse. And once there's an impasse, the party, the petitioner, which in this case maybe is the association, can proceed directly to court and seek an award of attorney's fees and costs that were incurred with the mediation. If the mediation is not successful in resolving disputes between the parties can go to a court of competent jurisdiction, or they can enter into binding or non-binding arbitration in accordance with the procedures that are set forth in the Condominium Act, which we just discussed. If they don't agree to arbitration proceedings following unsuccessful pre-suit mediation, then they can go to court. A final order resulting from non-binding arbitration, again, is final and enforceable if nobody files for a trial de novo within 30 days after entry of that order, the arbitration order. Attorney's fees, again, as I mentioned before, generally speaking, parties pay for their own attorney's fees, but if you're a bad actor, you're not going to be able to recover your attorney's fees, even if you're a prevailing party in subsequent litigation. So make sure that when you are served with these things, whether it be a petition for arbitration or a pre-suit mediation demand, that you are responding to them timely and following through with everything that's been scheduled. So let's say you have a mediation, there's an impasse, it doesn't settle at mediation. What happens next? Well, your other option is to go to court. Actions at law or in equity are both. Remember, we talked about that statutory phrasing. For the failure to comply with the association's governing documents can be brought by the association or any member against any one of these parties. So owners can bring litigation against other owners under the governing documents, which is usually what we suggest in neighbor-to-neighbor disputes. Prevailing party in any litigation is entitled to recover their reasonable attorney's fees and costs. However, if the member prevails in an action between the association and that member, whatever amount would have been assessed against that member for the attorney's fees, it would not have to pay that share. And now let's talk about our affirmative defenses. Now, I always couch this conversation to say this is not a roadmap to teach boards how to get away with things, but just a discussion to highlight the possible defenses and how you can avoid these defenses by uniformly and timely enforcing your governing documents. Selective enforcement, we begin with the most obvious one and the one you probably hear the most as a board member and manager. If a community association fails to uniformly enforce their governing documents against all owners, then an owner can raise the defense of selective enforcement against the association's enforcement of a particular covenant or restriction against them. Now, to prove selective enforcement, the owner has to show that there are apples to apples violations which the governing body had notice of but refused to act. Okay, we're not comparing apples to oranges. We're not comparing a pet violation to a maintenance violation. It really has to be specific to that same exact text or same exact restriction in the covenants. Selective enforcement, again, limited to similar violation, where the governing body has the authority to interpret its rules and regulations and decide what violations to pursue. The board's decision is not going to be subject to defenses of selective enforcement unless it's shown to be irrational or unreasonable. So, for example, a board, you have your set legal budget for a year, let's say, and you have so many violations, and you created a list of the violations, and the most egregious ones come first, and maybe there are some that are similar. Well, the association is not going to be held to a selective enforcement defense if, well, we have this on a list of violations, but due to our resources, we have to take them one at a time. So simply because the association hasn't commenced enforcement action against them, but it will, is not going to be something that an owner can say as selective enforcement. The owner has the burden of proving that there were similar violations and that the association had knowledge of those violations and took no action to attempt enforcement of the rule. There are some examples. I know I'm running short of time, but I really did want to go through these examples, but I'm going to have to let you guys read those examples. These are pulled from actual cases, whether it be from Florida case law, like our DCA cases, or through arbitration cases. Equitable estoppel, it functions as a bar to enforcement where there are representations of one party, usually the association, relied on by another party that results in a change to that party's position. And then the first party has a later contrary representation. We see this a lot. When it comes to, let's say, material alteration type issues or alteration to the lot type issues, where an owner has, let's say, painted their house pink without the approval of the association. Maybe the association either didn't know about it, or maybe they did know, and the owner of one other home down the road says, you know what, I want to paint my house pink too. And they paint their house pink, and now the association comes after them for saying, you didn't get approved for this. We don't allow pink in our community. Perhaps that owner, will bring the equitable estoppel defense and point to the house down the road that has pink painting as that reliance of what they relied upon to change their position. Now, whether or not that equitable estoppel defense would be successful is questionable, but here are some examples of that that you can go through on your own time. Latches really involves time. Latches is an unreasonable delay in asserting a known right, which causes undue prejudice to the party that asserts latches. Emphasizes the length of time for which the petitioner took no action to enforce their rights. The owner, who is usually the one asserting latches, has to prove that there was prejudice. One factor to consider in determining whether to apply latches is whether during the delay there has occurred a change in conditions that would render it inequitable to enforce the right asserted. So what length of delay is necessary to establish latches? Well, that's a great question. There's no bright line test there. Again, some examples for you guys to read at your leisure. You see here, some of them say 8 years, some of them say 4 years. It just depends on what the claim is as to what the court will determine to be unreasonable and prejudicial against the owner. And waiver, this is tying us back into the beginning of the presentation. Waiver is defined as one party's intentional or voluntary relinquishment of a known privilege or right. In order to establish waiver, the party asserting it has to prove the existence of the privilege or right at the time of the waiver, the actual or constructive knowledge thereof by the party against whom waiver is asserted, and an intentional or voluntary relinquishment of that privilege or right. Usually this shows up as, okay, the governing documents have prohibited pickup trucks, but pickup trucks are the #1 selling vehicle in America. So the board has decided, you know what, we're not going to enforce this rule. People, you can get your pickup trucks, and they bring out the pickup trucks into the community, and then a new board comes in and has said, excuse me, but the governing documents say right here, no pickup trucks. So we're going to send pickup truck owner a violation of the governing documents. Well, that pickup truck owner has a pretty darn good waiver defense to the enforcement of that against them. And here are some examples of that as well, if you'd like to read them at your leisure. I do want to give maybe a couple minutes for questions. So let me stop my share.
Yeah, and while Danielle's looking at the questions, nice job, and she did fantastically, folks. If you don't know, I've been hounding her to speed it up behind the scenes, and she did so well. Thank you for
Sorry.
that. Folks, in the chat area, we placed the link for the evaluation. Click on that link, fill out the evaluation, then you can go and get ready for the next one if you happen to have signed up for the next one, which starts in about 9 minutes or so. So Danielle, if you want to head to the Q&A, do a couple of
Yes,
them before we
so
head out and give everybody a couple of minute break.
I'll do this first one that Karen asked here. Previous boards enforced rules differently. Do we need an attorney developed resolution to say we will start enforcing more consistently going forward, or can we just have a board vote at a meeting? I don't think you don't need a formal attorney developed resolution per se. I think what you do need to have is a board meeting and a motion to say, we haven't been enforcing this consistently in the past. Any violations that are currently existing are grandfathered in, but we will be enforcing this going forward. And there's a case on point, it's called chattel shipping, where they did just that. So even if you have something that hasn't been enforced in the past, we call it a reinvigoration. You reinvigorate the rule at a properly noticed board meeting, and you send notice out to all of your members to say, hey, watch out, because we will be enforcing this in the future. There's some good questions, but not necessarily like the impact of changes with regard to Kaufman language. We do have a legal update course, which you may want to take advantage of.
Yeah, folks, if we don't get to a question, please don't take it personally. Today, more than usual, for this bonus section, for this bonus time, we are pressed for time because we have 3 other classes back to back to back to back.
Yes.
There was
If you
one.
don't have a finding, sorry.
No, go ahead.
So there's one question here about not having a finding committee. If you don't have a finding committee, or a hearing committee is more so the better term, you can't fine and you can't impose use right suspensions for non-monetary violations of the governing documents. It's simply not going to be an avenue of enforcement that you can take. You still can use right suspension and voting right suspensions for delinquencies greater than 90 days. Again, with a voting right suspension, look at your governing documents to make sure that you have that express authority. But really, you're going down the avenue of notice of the violation, pre-suit mediation demand, and litigation. In which case, if you're a prevailing party, you can get attorney's fees, an award for attorney's fees. Now, an award for attorney's fees is not going to make you 100% full. You're lucky if you get 75% of your attorney's fees that you spend back from the court order. So
Yeah.
it's not going to make you whole, but it is better than nothing.
Hey, Danielle, which class do we talk most about Kaufman language? Patricia's asking if we have a specific Kaufman course, which we don't, but there's one we talk about it quite a bit.
Yeah, so if you attend one of our board certification courses, which apologies, those are our longest courses, but that is where we do dive into the Kaufman language discussion, particularly for our homeowners associations.
And Patricia, if you already have your board certification, if you're a board member who already took that class, we have some recordings on kbrlegal.com that you can refer to, and Danielle has even done a couple of those. So at kbrlegal.com, go to the resources tab and then webinars and videos. And with that said, I need to cut you off, Danielle.
Yes.
We're going to have to head out.
Email me. I do try to respond to them as quickly as I can. So send me an email, and if I can answer, I will.